model rules a clear statement that a lawyer is not to be associated with, or a lawyer's advocacy on behalf of a client should not or does not express a lawyer's agreement with the client's point of view or the client's political or moral or business activities. That's a statement that the ABA puts into its model rules about what its view of a lawyer taking on a client's case should not be read to express that the lawyer shares the client's outlook. But yet when we look at these other civil rights movements, constitutional rights movements, like you say, a Thurgood Marshall or Ruth Bader Ginsburg, certainly we associate these lawyers as not just being advocates or hired guns that pursued these legal arguments, but that they were deeply involved, morally committed to these causes, and to the extent that we regard those movements as honorable, crucial, that they become honorable figures. But to the extent that we can that the development of corporate constitutional rights is more controversial and even criticized, as you say, by large swaths of the American public, in what way should we regard then the lawyers or the ethics of the lawyers who are involved in these kinds of cases? In the early part of your book, Daniel Webster seems to he pops up and he seems to be highly motivated by the very large legal fees that he's drawing from these cases, and a lot of these lawyers seem to be making a lot of money. Maybe they have collateral political or social interest, but they're taking on these big corporate rights cases for the money. And then later in your book, you talk about the development of a really distinct, highly skilled professional Supreme Court bar. And I just want to read the one striking sentence on page 347 of the book, where you're talking about the development of this cadre of lawyers. And you say, certainly for most of the elite, specialized Supreme Court lawyers, the proverbial game is the thing. That for the contemporary Supreme Court bar, it's the game. It's appearing before the court. It's developing sophisticated arguments. It's winning before the court. It's the game. So maybe it's the money, maybe it's the game, but it's not typically like it is for Marshall or Ginsburg, a deep moral devotion to these issues. So do you have a view of the legal ethics of this? Should we as lawyers, should we as law professors, should we as professionals, should we as citizens hold these lawyers accountable for the causes, for the substance of the cause that they're committing to, or should we recognize or regard them as just participants in a game, and we must evaluate the substance of the issue without impugning the lawyers involved?
Well, certainly there's nothing in today's rules of legal ethics that would prevent corporations from having counsel, and even having creative counsel that fought for the rights of corporations. Whether we have a personal ethical problem or we think that's society-wide problematic, I guess we as a society haven't really come to that conclusion. In fact, as you mentioned, we're seeing today the rise of an elite Supreme Court bar of lawyers that's unusually well-trained and influential in the Supreme Court, and they represent primarily business corporations and trade associations that represent businesses. Do we want to hold these lawyers responsible for the rights that they're fighting for? That's been an age-old question in the law. Do we want to hold lawyers responsible for the views that they express in a court of law, or do we think of them really as agents of a client principal who is entitled to zealous advocacy on their behalf? I don't think the corporate rights area will be where we'll find ultimate determination of that long-standing controversy. It applies in the context of heinous criminals, terrorists, drug dealers, serial killers, and others. Generally, what we've decided in America is that everyone's entitled to adequate and full representation. But we should recognize, nonetheless, that when we have corporations with the same rights as people, to spend their money to fight Supreme Court cases to win rights, we're going to have a system in which corporations really win. because they've got the most money. They've got the willingness to spend that money, to invest it in high-risk litigation to try to seek new legal protections and to fight lawsuits to overturn burdensome regulation. And that's what we've seen over and over and over again. The American judicial system has extended our most fundamental rights to corporations in part because that system is really designed in a way that favors the resource-rich business corporations that have marked American history.
It's interesting. You try to address that ethical issue, and you say, and quite rightly, that there is this long-standing principle that everyone has a right to representation, really whether it's in the civil or the criminal context. When course private interests are at stake, everyone has a right to counsel if they can afford one, and corporations certainly can. But again, when we even phrase it that way, we use that phrase, everyone has a right to representation. Again, we're put right back into that question of conceptualizing the corporation as an association of people, everyone's, an association of people who have the right to representation, have the right to their interests represented, or is it a distinct legal entity, a distinct legal person? And if we are to regard the corporation merely as a distinct legal entity, does that ethical conceit that everyone has a right to a representation include this merely artificial entity, or do we include that in the everyone? And I guess on your general approach, when you talk about treating the corporation as a legal person, for you that doesn't denude it of all legal rights and responsibilities, and so maybe it gets to participate in that ethical conversation as well.
Well, I would think that we wouldn't want to have a system where corporations did not have a right to counsel or did not have a due process right to appear in courts of law and to raise legal challenges to laws that burden them. If they could not, then the next time the FBI wants Apple to open up an iPhone of a suspected terrorist, Apple won't be able to go into court and say no and fight against that. The government will be able to come right in and just order Apple to do it. And what would Apple's recourse be if they can't go to court and say, hey, we have rights to our property and due process, and the government can't come in here and just take our stuff? Yeah. So, I mean, I have great sympathy and totally understand where people are coming from when they think corporations should have no rights, or only those rights that we decide as a society to give them for public policy purposes. But we have to recognize that there are really serious implications to that approach, and there's probably a really strong reason why the Supreme Court has never gone in that direction. Mm-hmm. And it's not just because the Supreme Court is very business-friendly, although that might be the main reason why the court has done that, but also legitimate pragmatic concerns that if corporations don't have those basic rights, then no one will invest in corporations, and government power won't be limited in the way that the framers kind of imagined. Mm-hmm. So these are difficult questions, to be sure, and the line drawing is very difficult. But I definitely think that just as corporations should not have all the same rights as you and me, probably shouldn't think about them as having none of the rights of you and me.
If I can squeeze two more in here. The first question I really want to ask you about, again, the book is so impressive, and so many people have talked about what a pleasure it is to read and how edifying it is. Can you tell us anything about your process as a scholar, as a writer? How did you write this book? What's your approach to doing the research, to conceptualizing the chapters? Anything you want to tell us, or any insights you have for scholars, for writers out there, just in terms of your process that we might be able to learn from?
Well, certainly. So I will say the process for this book was I had a basic idea, and I just went and started researching, and I knew some of the stories, but frankly, I didn't know half the stories. And there are many chapters in the book that I had no idea about when I started working. That was actually a mistake, I think, if you want to know my advice for future writers. I've written two books, one that wrote very easily, my book about guns, and this book on corporate rights, which took much, much longer. And I think in large part it was because I had a much better sense of what the structure of the book and what every chapter would say on the gun book when I started out than I did on the corporate rights book. And that required me to constantly be rewriting it. And honestly, my book has had great reaction, and if you gave me a chance, I'd rewrite it again today because I see it in different ways. In terms of the actual style of writing, I do find that one of the most rewarding things about my books and the reaction that my books have been getting is that they're very easy to read, that they're good reads, that you enjoy reading them in the way that you wouldn't expect to read a book written by a legal historian. And I think the key to that is just basically trying to reverse the way scholars write a paragraph. Scholars write a paragraph by beginning with an idea and then supporting that thesis with evidence at the end. Right? That's the structure of academic and scholarly arguments. I think if you want to write to a bigger audience, to a popular press, you have to just flip that, which is you start with the evidence, you start with the anecdote, with a person, place, or event, and then use that as a basis for then drawing the conclusion that is what a scholar would say is the hypothesis. And by flipping it, you find that the paragraphs become much more readable because they're about people and events, not just about ideas. Ultimately, the takeaway is an idea, but the paragraph reads as if it's about a person. And I think that scholars can really benefit from doing this. If you want some advice, I like to pick up articles of the New Yorker and break them down. How are they structuring their paragraphs and their sentences? I think that the New Yorker is a particularly good venue for thinking about how to present scholarly and academic ideas in a way that's immensely readable.
That's a great tip. Thank you very much for that one, Adam. All right, then let's close with I invite your reflection, but I don't insist upon it if you haven't developed your thinking on it yet. But we're talking here just a couple of weeks after Senator Elizabeth Warren made a pretty big news splash in filing a piece of legislation she calls the Accountable Capitalism Act. I think it's the new ACA, if you will, the Accountable Capitalism Act, which would very dramatically restructure corporate governance in the United States for the very largest corporations. In her legislation, the rough of it is that corporations that have revenues of more than $1 billion would be subject to a federal chartering requirement that would require 40% representation of workers on the board of directors, and that would charge corporations with a governance command that would be not limited to pursuing profits for shareholders, but would impose on them responsibilities to govern with an eye towards the interests of multiple stakeholders. The Warren proposal isn't going to be turned into law anytime soon, but it is a formal piece of legislation now that I think makes corporate governance a much more salient feature of our active political conversation. And I wonder if you have any reflection on what kind of guidance your book or your work in this area has, not decisively in terms of saying whether this is a good idea or a bad idea, but in terms of informing how we should be thinking about big proposals for corporate governance reform in our public policy debates today, specifically with reference to Warren's proposal.
Well, like you say, Warren's proposal for a more stakeholder-centered corporate governance regime is unlikely to be adopted anytime soon, but it does reflect an idea that that one way to get around problems like Citizens United and what many people see as the corporate takeover of American democracy is not to change fundamentally the Constitution, as some people have proposed a constitutional amendment to end corporate rights, or not necessarily to overturn Supreme Court cases so quickly, but to reform corporations and reform corporate law, to make corporations more responsible, to make them more diverse in their perspective and responsive to stakeholders other than short-term focused shareholders. If we think about in this, a friend of mine who also works on corporate rights, a professor at Boston College School of Law named Kent Greenfield, has a book coming out in just a month or two called Corporations Are People Too, and They Should Act Like It. And the idea being that Yes, it's true, corporations should have some basic rights under the Constitution, but the answer for mistaken cases like Citizens United that take those rights too far is really reforming corporate law to make them more responsive to the public and to we the people, not just to shareholders. And then when corporations spend